The personal views expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a very special guest all the way from the United Kingdom, Robert Bateman. He is the owner of KnowData Ltd. Welcome.
Great to be here, Debbie.
Well, I've known you over the years. We've gotten to know each other over LinkedIn over a number of years because of a lot of your great writing and advocacy around privacy. You do a lot of deep dives. I love the videos that you do, the presentations that you do. I actually had a chance to meet you in person in London at one of the Global World Forum events. I don't know if it was Risk. Can't remember which one it was. But anyway, that was fun to meet you in person. And I love the fact that, you are a LinkedIn top voice. You do really put out a lot of content that's very helpful. And I always make sure that when I'm talking to people and they say, who should I follow? Like, definitely follow Robert. Like he brings a lot of knowledge and a lot of information to the space. But welcome to the show.
Thank you, Debbie. That's so nice to hear. And yeah, I recall we met quite briefly in the audience at London event. One of those put on by my old employer. Could have been PrivSec or Risk. So that was nice. And yeah, I've been following you on LinkedIn since I started thinking about this stuff, really, and very much appreciate your work too.
Excellent. Well, you are very prolific in what you write and the things that you present on privacy, and you do a lot of writing with, some other companies as well. And, I just want to get your thoughts on, first of all, how did you get into this? So how did you become such a champion for privacy? Why is this important to you?
Well, it started when I was doing a law degree. And I guess it would have been 2017. I started during the break. I wanted a kind of side hustle. So I started writing for privacy service provider about the GDPR, which was quite new at the time, and the CCPA, which was also very new at the time. That was 2018, of course. And I used my knowledge gained from the course, law, and found it very easy to write about this topic and found it quite fascinating. So they wanted articles about every single aspect of the GDPR. There was even a kind of article by article breakdown of the whole law. And just by doing that, I sort of embedded all this knowledge about the field in my head. I then did research projects as part of the law degree about the UK's Data Protection Act. There was a provision called the Immigration Exception, which allowed the government and private companies to exclude subject access requests on a very broad grounds of sort of maintaining immigration control or something like that, which I felt was very problematic under human rights law. So that kind of helped me appreciate how important this stuff can be. And since then, I have done lots of little jobs and lots of writing. Then I moved into training, and I was working with this events company that you mentioned earlier, putting on events about data protection, meeting lots and lots of people from across the industry. Now I focus mostly on consultancy and also training. So yeah, that's how it started and where I'm at now.
Well, you do a great job. You do a great job of really reaching out and being able to share your knowledge with people. I think one of the things I admire about you as well is that I feel as though not a lot of people who are outside the US really understand the craziness of the way law works in the US. And I think that you understand that really well.
Yeah, that has been a real interest for me over the past few years. Less so right at this moment because I'm mostly advising clients, and it's slightly tricky to do that, in certain areas of US law. But the US privacy scene is endlessly fascinating and, developing so quickly and so dramatically. I think, what are we at now? 21 states with a comprehensive privacy law, and lots of enforcement from the FTC, much more active than many regulators here on this side of the Atlantic. And of course, the sectoral considerations, it's really, really messy and really overlapping obligations and exceptions and carve outs, and the various obligations from different parts of the law, federal law, state law. It really gives me a lot to think about and lots of new developments to follow. The EU privacy law, data protection law can go around in circles a little bit, 5-year long debates about the meaning of a particular word in a particular paragraph. Whereas in the US, you haven't quite got to that stage yet. And the law is still developing in some really interesting ways.
Yeah. The US is very confusing. It's a very confusing privacy landscape, especially because we have, federal rights, we have states' rights, and those things are very incongruent. And then we have these pushes that have been happening and probably will continue even more forcefully to try to get some type of legislation on the federal level that tries to preempt some state laws, even though not all state laws can be preempted in that way.
Yeah.
So I think the next few years will be very interesting, to say the least, in the US.
You pointed something out to me about preemption of state laws, I think, a few months ago. And the fact that, well, I kind of knew this in principle, but the American Privacy Rights Act, how it would preempt some parts of, for example, BIPA or BIPA in Illinois and not others. And it's just, you can see why, I think, privacy law is most or more so the domain of lawyers in the US than in Europe. I think there are other reasons for that too. It's so hard to grasp these subtleties without having some good legal understanding of, the different levels of power and federal, state, and so on, the way litigation comes into it too. And also, it's kind of a little bit more tenuous because you have these cases that can knock down a law on federal constitutional grounds, like is happening with the age appropriate design code in California, where what are they called? Net fair or something like that, or bringing a case saying that the law itself is unconstitutional, certain provisions of it are. And so I always wonder about all these new state laws. Is it kind of a house of cards waiting to be blown down, which keeps it kind of dynamic and interesting as well, if very confusing and uncertain?
Yeah, and I think one of the things that we lack here in the US is we don't really have a body that can work on privacy is not related to elections.
Right.
Right. So, like I wish we had like an EDPB, like a board that, it's like, okay, this is the board and they're working on privacy and they're not trying to get elected or not afraid that they're not going to get elected. So a lot of the push and pull that happens in the US around privacy and laws happen around like who's in charge or who's going to be in charge or who's not going to be in charge, right? So
Yeah.
even the most recent push in the US to try to get a law out on a federal level, one of the senators that was pushing the law, she was retiring. So she thought, well, I could do whatever, right? Because I don't have to worry about trying to get elected. And so, I think that tension is always there in the US.
Yeah, on many levels too. I guess the FTC has some degree of independence, but Lena Khan won't be there forever, and she has changed the face of that agency so much. It could be really dramatic when post comes to an end. Of course, then you've got the Supreme Court too. We don't know what they're going to do with various rulings. And what was the case a couple of weeks ago, Chevron, which talked about whether courts have to follow regulatory interpretations of laws. Those kinds of things are really easy to miss, but have huge implications for the everyday work of privacy professionals, I suppose. It's just very difficult to predict how things are going to go and how these changes will manifest, particularly in the US, I think.
Yeah. So what's happening in the world right now that's concerning you most about privacy?
Well, we're speaking on the day that I think is official now, the election of Donald Trump. So I was thinking about trying to write something about what could happen with AI, privacy, digital kind of policy under him. It, it's just so hard to say again. I mean, I saw an article a few months ago by someone talking about the US data privacy framework, the data transfer mechanism, and how Trump's re-election could have implications for that, because of course it's all based on the rule of law. If we take things seriously that he said during campaigning, then maybe there are some concerns around, the kind of robustness of democratic institutions in the US that could have implications for that adequacy decision. That's the kind of first thing that came to my mind when you asked, because it's so relevant as we're speaking, perhaps not as people are listening to this, but the other developments, I guess, this side of the pond, the UK has just put forward its second attempt, well, third attempt technically, at reforming its data protection and privacy framework. The EDPB that you mentioned earlier has been very, very busy bringing very strict interpretations of the GDPR and the e-privacy directive. The AI Act is starting to kick in the EU. So there's no shortage of things to discuss. I can't really pick one as the thing in which I'm most interested. I do this kind of newsletter for a client every other week, and it's really a matter of choosing what not to write about, because I never struggle for topics. There's so much going on.
Yeah. I guess if I had a crystal ball, what I think the implications of the election will be is that there probably will be, they'll throw up a federal bill, but it'll be like a really wafer thin bill. And because they have the Senate, they may be able to vote in a bill that's like very weak and very thin so that they can do some, at least some level of preemption, because that's what a lot of the corporate people have wanted for a while. But again, because states are a bit different, I think that there are still going to be a lot of states that are going to pass their own laws, and they're going to probably start to pass more of those general applicability types of laws that cannot be preempted. So that's kind of what I think is going to happen with privacy. So I think it's going to get a lot more crazy.
Interesting. So they got the Senate, and they could introduce a new law kind of to replace a new bill to replace the APRA. You think, Debbie?
Oh, yeah.
And doing something that pays lip service to the idea of a federal privacy law. I don't know whether that would be better or worse than nothing at all. Some people say that's what the APRA was, the American Privacy Rights Act. I think that was a little unfair. I mean, it is quite a meaningful bill, but if you, as in the US, pass a law that looks like a federal privacy law but doesn't have much effect, then I suppose some people might consider the debate closed for a couple of decades. So it might actually be not represent much progress legally.
I think what I'm seeing, and I want your thoughts about this, and I think it's really interesting. So I think just like the GDPR was very influential in the US on privacy, I think Artificial Intelligence Act will be similarly influential. I think we're still seeing that on the state level, and I think that will continue to happen. Also, there are some regulations that are happening in Europe about things like the Internet of Things, about labeling and how those devices companies need to share information about data. And because of international trade, I think, and we don't have anything like that in the US, I think that's going to push companies to try to align with some of those things, even if there isn't regulation in the US, because it's going to be a barrier to commerce, I believe.
Yeah, I think you could well be right there. I mean, the US actually managed to, well, Biden managed to pass the AI executive order before the EU finalized the AI Act. And of course, it's not as significant or as difficult to implement as the AI Act in the EU. But that was interesting that they were really quite proactive on AI. And of course, I wouldn't bother trying to predict what Trump would do in this area. I think he has given mixed messages about AI regulation. But the point about international trade, it might you might be right. I mean, the legislation could catch up with changing business practices. For example, you referenced there, I think I get these ones confused, but maybe the Data Act or the Data Governance Act, one of the two, which applies to Internet of Things providers and forces them to share data in particular ways. And US products on the EU market, it might not be worth US providers kind of designing EU market specific products, especially when it's so core to the product itself. You know, with GDPR, I suppose you can do a bit of tweaking to ensure people have access to the data and can delete it and so on based on where they are. With if it's something you really do have to bake into the product yourself, as applies with AI Act and the Data Act and so on, perhaps it will change company practices so much that they say, well, we might as well legislate for this now because people are doing it anyway, and it's not harming their companies. We could have these standards in the US as well. Maybe you're right.
Yeah, I think the next battleground, which will be, in my view, kind of around standards, right? So whether that be IEEE or ISO, these organizations are very active in the standard space, especially as we have more products that are collecting data. So even NIST, I think that guidance will be very influential about how we kind of move forward in the future as we're using more things that are internet connected or things that are collecting personal data. I think that guidance, because it's not in the political form, and these projects go on for many years, I think hopefully there'll be more kind of privacy by design, or like I like to say, safety by design things that happen where it there'll be an impetus to move in those directions because it makes trade better. It may make people trust what companies are doing with these things, and these standards organizations don't really wax and wane with who's in office at the time.
Yeah, and we do have several references in, off the top of my head, I think it's Tennessee and the Tennessee Information Protection Act, and also the Colorado AI Act, and also that Biden executive order I mentioned. They cross-reference some of these voluntary standards to kind of give organizations a safe harbor of some sort if they're accredited under them or they comply with them. So maybe that could be, maybe, yeah, I think you're right. They could be increasingly important going forward as companies look for ways to kind of harmonize their operations on both sides of the Atlantic. And it's interesting to see these standards referred to specifically. It's always as an example, like an equivalent to ISO 27, whatever, but they do give companies an impetus to comply with those standards. And they are, I've seen a few clients recently going for ISO certification, and a good certification provider, suitably rigorous, it really is very meaningful. It can really bring an organization's standards up. I used to think of it as a bit of a checkbox kind of thing, but it can be very detailed and rigorous process and do a lot of good. So maybe that is a good way forward for companies in jurisdictions where they don't have direct legal obligations to do certain things.
Yeah. Well, I want your thoughts about data transfers, whether they be well, in the US, well, I don't know, state to state, but like the international data transfers. This is a area that you write about a lot. This is some of your most interesting writing to me because I feel like that's probably the most complex part of privacy, how to square the different laws of different jurisdictions and how you share data across. So I want your thoughts on that.
Yeah, it's a really interesting area for me. And I do find it very frustrating at the same time. But I find it hard to settle on a good kind of policy position or opinion as to what we should do. Because, well, obviously in the EU, we had the Schrems cases and we had the very strict interpretation of those cases by the EDPB, which mean that for a period of time before the EU-US data privacy framework was agreed, as we were discussing earlier, millions or billions of illegal data transfers were occurring every day, I think, because people don't quite appreciate how strictly worded the law is and how strictly it's interpreted by the regulators and arguably the court. So there was a period of time where I think, well, we know that we had the Google Analytics decisions in the EU, where I think about 10, 15 cases where website operators were deemed to be in violation of the rules on international data transfers by using Google Analytics, because Google would, in the course of providing its analytics service, transfer some data to the US. Now, the reason I raised these cases is because the types of data Google transferred to the US via Google Analytics were about as kind of technical and potentially benign as you can imagine. It was bits of people's IP addresses, which websites someone associated with that IP address might have been to, and maybe some association with a Google account, depending on the implementation. Now, I'm not saying that Google is a completely benevolent organization as far as privacy goes, but those sorts of data transfers were about as kind of low risk as you can get, I think. And yet they were still deemed to be in violation of the data transfer rules, consent or no consent. At that time, there was no real way to conduct those data transfers legally. And I just wonder who really, and there might be someone, some activist or, disadvantaged person, but who is likely to be harmed by that type of activity? And on balance, I think nobody. But if we had, maybe some people, but it's difficult to imagine how the NSA would be interested in that sort of data or would use it in any kind of malevolent way. But, with the law as it stood and as it was being interpreted, those things were pretty much illegal in the same way as transferring people's credit card numbers directly to the Kremlin would have been. These were treated as equally serious violations of Chapter 5 GDPR, just because the law is written in such a kind of blunt way and have been interpreted by the authorities in such a blunt way. But if you press a switch and automatically every company in the EU was, all those unlawful transfers were shut down, it would have been total carnage. The hospitals would have struggled to keep the lights on, I think. And, air traffic controllers might have had issues because data just flows internationally by default now. So the kind of disconnect, I think, between what the law said and what was happening in reality was quite fascinating to me at that point. And, it still applies to some extent, but less so at the moment.
Yeah. Actually, it's interesting that you brought that up because when those rulings came down, I was very concerned about it, as were you about that, in terms of the banality of some of the things that they were trying to stop. I understand it in principle, but also the thing that concerned me about that is that because Google Analytics is such a widely used product, I have clients in Europe as well, and they never stop using it, right? So I think to say that you need to stop using a product because it's gonna because it's illegal in some way, but then really not giving someone like an alternative, what they should do. I think it becomes a concern because it makes it seem, in my view, it makes it seem like businesses think, what's the risk to me? Or maybe I shouldn't comply with this, right? So I think
Yeah.
what you really want in laws is to make something, you want to make it meaningful, but you also want to make it something that a company can really implement. And so that was my concern with that, where I felt
Yeah.
like a lot of companies have been so embedded over decades, probably, as long as Google Analytics has existed. And for them to really rip out that tool and there was really a comparable alternative for them
Mhm.
makes it hard, because I feel like businesses want to comply with laws, but if you make it too hard for them, I think they won't comply, and then it makes it hard for them to take the regulator seriously when they
Yeah.
do things like that.
I agree. And it wasn't just Google Analytics, of course. As you know, it was pretty much any US based service provider. And the argument in favor of having strict data transfer rules like that, I mean, there is one. Of course, you go back to Snowden and the kind of surveillance industrial complex or whatever you want to call it. You've got the NSA can make very good use from metadata, as we know. I don't personally care if they are able to associate my activities on, you know, random Amazon website or whatever with my IP address, but some people do, and they, I suppose, have the right not to have to worry about being surveilled. But the cost sort of risk analysis didn't come up in the EU's favor, I don't think, for most businesses. It's hard to explain what the risk to them is, and it's even harder to explain what the risk to anyone else is. Because if you're a random example, a carpenter with Google Analytics on their websites, how do you explain the risk associated with someone visiting that website and their data being sent to the US? I mean, there isn't one. It doesn't exist. So I do think that that strict interpretation of the law, not necessarily incorrect based on the court's reading of the law, but the implications were pretty bonkers, I think, in large parts.
Yeah, yeah. One case that you talked about, and I would love to get your thoughts about, maybe just for the audience, just give like a brief overview of what's happening, what happened with that case. And I saw your writing on this. And this was the huge Uber fine. I think it was like over $200 million they were fined about a data transfer mechanism. And I thought your point of view was really interesting there because I think that they were being slammed because they weren't using standard contract clauses. They were using a different mechanism for data transfer. And so tell a bit about this case and your point of view there. I thought it was really interesting.
Yeah, I had a bit of a hot take on this one, as they say. I think it was 288 million euros it got. So let's let's talk it through. So in late 2021, the European Commission came out with its new standard contractual clauses, and Uber previously had the old SCCs in its agreement between its EU entity and its US entity, and they were joint controllers. So they covered transfers between those two entities with the old SCCs. When the new SCCs came out, the commission that publishes the SCCs, drafts them, gives them legal effect, published an FAQ document, and indeed said similar things in the actual legal decision that gave effect to these new SCCs, that they are not to be used for transfers to an organization that's directly covered by the GDPR under Article 3.2. And you can see why, because these SCCs, the whole point is if a company is outside of the EU's jurisdiction, these clauses kind of put contractually on them the GDPR requirements. So there's no statutory requirement for them to, for example, help facilitate data subject rights. So therefore, you put a contractual requirement in place. If the company in the US is covered directly by the GDPR, for whatever reason, then the commission said there's no point kind of duplicating these requirements under contracts, under the SECs, because they might even contradict what the GDPR says directly, which is true in a couple of cases. There is a bit of tension. So Uber said, okay, fine. So we won't use the SECs then to transfer data to a US entity because it's covered by Article 3 to the GDPR. Now, this was a mistake on Uber's part, and they got some complaints via France. The Dutch Data Protection Authority looked into them and discovered that Uber did not use SCCs. They did not consider, or Uber didn't consider these to be international data transfers that required SCCs because of what the Commission said, both in its FAQ and also the implementing decision to which the SCCs are an annex. So they said basically, the upshot is, it's not that we disagree that Uber US is covered by the GDPR, we just disagree with the Commission. The EDPB's position is that regardless of whether the importer is covered directly by the GDPR, the exporter still needs to put SCCs or something in place. And another problem is that the EDPB did not state this position until about 6-7 months into the investigation into Uber. So Uber didn't even know really that that was the EDPB's position. They were supposed to just read the law themselves, come to their own conclusion about what it meant. And the fact that the correct conclusion, according to the EDPB, contradicts that of the European Commission that kind of wrote this law, didn't count for anything. So it was, for me, an example of how confusing this area can be and how the kind of tension between these EU institutions can cause real problems. And the Commission said, actually, in addition, it was working on SCCs to cover those sorts of transfers between EU entities and non-EU entities that are directly subject to the GDPR. They haven't done that, but they did start doing it about a week after Uber's 288 million euro fine was announced. So they have started doing that now, 2 years after they said they would, 3 in fact. So it's a real mess. And at the end of the day, if Uber had put those SCCs in place, I don't really see what difference it would have made to anyone. You know, it doesn't affect anyone. Uber US presumably felt it was legally obliged to do these things anyway. It's just a piece of paper. So it kind of made it all seem a little bit absurd and pointless. Other people disagree with my take on that, but I think I still stand by it.
I liked your hot take on that. You know, what I had been seeing, because companies were sort of confused about this, some of the companies that I knew, the bigger companies, they did a belts and suspenders type of thing where
Yeah.
they did both.
Yeah, I wasn't advising a lot at that time, but I would say just do it anyway, just put them in just in case. So that's what Uber should have done. But it's not, the fact that they should have done that for practical reasons. I don't think it detracts from the point that it's just the ambiguity and the lack of certainty is a problem, I think. Under the rule of law, you're supposed to be able to predict how laws will affect you. And this contradictory information from the people that wrote the law and the people charged with enforcing it, I don't really think that's good enough. It shouldn't be happening like that. I know there's not much sympathy for US tech companies, but that's beside the point, I think. It could be a US tech company today or an individual person tomorrow. The law needs to be clear and applied kind of fairly and in a predictable way. And I don't think it was in that case in particular.
Yeah. And where is that case? Is it being appealed? Like what's happening with
I'm
that?
pretty sure Uber are appealing. And then we're
Yeah.
going to have these new SECs eventually released from the commission cover those sorts of circumstances. That will make things even more confusing, I think,
Yeah.
because then it will be about establishing whether the company is in scope of the GDPR directly, which set to use. Is the EDPB even going to recognize this new set of SCCs? So I think the confusion is not going away.
Oh, yeah. Well, if it were the world according to you, Robert, and we did everything you said, what would be your wish for privacy or data protection anywhere in the world, whether that be regulation, human behavior, or technology?
I would like to have a formal recognition of privacy as a human right, everywhere, which it isn't, including to some extent in the US. And I would like that to be compatible with all the great technologies that we use day to day, which, I do indulge in the use of US service providers and data hungry services myself. And I would like to be able to choose to do that regardless of the fact that there is a kind of flaw protection for privacy as a human right. I have been observing, and this is almost a cliche now, but businesses are taking this stuff more seriously. I really do believe that. I have seen it even among the kind of the naughty companies that are constantly getting fined, your Metas, your Googles and so on. They're spending a lot of time and money thinking about how to do this stuff right. Whether you think that's cynical or they're trying to avoid it, it really is a discussion on the table now. So I really hope that continues to be the case and is even more so. And also, I hope that we do not place too much trust in AI systems as they develop and are integrated more and more into our daily lives. I hope that things like Article 22 of the GDPR and some of the protections in the AI Act are taken seriously and implemented properly and extended to other parts of the world where AI-based decision-making is liable to become more prevalent. So a little bit of a vague kind of jumble of things there, but I think that recognition of data protection and privacy, how that can feed into strong AI practices, not letting AI decision making take over. It would be a total disaster at the moment because it's not reliable enough. But even if it were, I would still like to see that human element retained in important decision making.
I share your dream, your wish for privacy to be a fundamental human right everywhere, especially in the US. And I agree. I mean, this is a complicated future that we have with the way the technology is developing and what that means for privacy. But I think, it's just going to be a bit of a strange period probably for the next few years as we kind of navigate this rapid advancement in, implementing new technology and what that means for personal data.
We live in interesting times, which some people see as a curse, but it does mean there's lots of stuff to write about, at least.
Oh, you have no shortage of things to write about, I think. So, yeah. Well, thank you so much again for being on the show. It's a pleasure to be able to have you on the show. And thank you so much again.
Great to talk to you, Debbie. So glad I could come on. Thank you.
All right, I'll be following you. And everyone, please follow Robert on LinkedIn. His profile is outstanding. He does a lot of really deep dives. I like the videos that you do as well. So people can get a bit of education when they look at your profile.
Thanks again, Debbie.
All right. Bye-bye.